Hello, everyone. I'm back again for another podcast. This is, of course, Finance, Fraud, and Forensics, and I am Bill Jennings, your host. I'm here today with a lawyer named Bill Holley, who I've had the great honor and privilege of knowing and working for over the past, 25 plus years. He's given me some of my greatest adventures, and he is a lawyer who is not only extraordinarily talented and knowledgeable about the law, but brings a creativity to these problems that result in solutions for his clients that aren't available to other victims in actually the same crime or the same circumstance. So I wanted you to hear from him today. He has some awesome insights about the type of case that we're going to talk about. I selected this case. Of course, this is a very recent case. This is July of this year. But it's a pretty large Ponzi scheme that caused investors across the country to invest, quote unquote, over $115 million and lose more than half of that. And Ponzi schemes are particularly brutal. Of course, most of the people watching this will have seen the stories about the Madoff Ponzi scheme, and they all sort of have that common element, which Bill and I are going to talk about today. Bill, prior to practicing law in the private sector, and incidentally, I believe I said this earlier, but he's a partner in the law firm of Parker, Hudson, Rainier, and Dobbs, which is here in Atlanta, Georgia. But prior to that, he was in the JAG Corps. He was a military lawyer and had a tremendous amount of trial experience in that context as well. So without further ado, I give you Bill Holley.
Thanks, Bill. It's a pleasure to spend time with you, as it has been over the years in any of our cases. And I immediately saw some of the parallels in this recent New York case to a one that we have worked on, but also it gives us the opportunity to talk about some philosophies in approaching these types of situations when you're seeking to represent or are representing someone who's facing a potential serious loss.
Well, and while we'd like to talk to you about the case that Bill and I actually worked on, of course, professional ethics and our client agreements prevent us from doing that. And so we've picked this case as a surrogate. I'm just going to give you the highlights and use that as a framework for Bill and I to discuss what's unique about these cases and what is important in terms of how to approach resolution. So this case is a Rochester, New York man who, his name is John Law. He's 41. He was indicted on July 28th by a federal grand jury on fraud charges. And basically the scheme was that he and other of his cohorts set up something called First National, Nationle. If something's misspelled in that way, that's a red flag right there. I mean, so stop right there. Solution LLC and something called Broyles America. And then basically what they did is using online virtual outreach as well as company websites, printed materials and in-person pitches, they basically solicited more than $115 million in quote investments unquote from investors across the country. Thought they were investing in operating businesses, and those investors, in exchange for their investments, received promissory notes, and basically none of the businesses were operated. Instead, these fraudsters basically took the money, spent a great deal of it on personal luxuries and expenses. We call that sex, drugs, and rock and roll in the business, and then use some of it to make only the minimum required payments that were expected by investors who sought those payments. And so when the music stopped, unfortunately, of the $115 million, more than $70 million of it was gone. I mean, literally gone. And so the investors, and even the bad part is even some of the investors who received some, minimum payments probably will be fighting in the bankruptcy courts to hold on to those. And Bill's going to talk a little bit about how that mechanism works in a minute. So that's the framework, that's the structure. And I'd like to open, Bill, by saying, let's say those investors approached you and said, hey, here's what's happened to us. They hand you a copy of the press release from the U.S. Attorney's Office. You're able to develop some other baseline information. What do you do? What's the right way to help these people?
Yeah, so the first thing, Bill, and as you know, the saying that we have is that first in is generally best out.
Yeah.
Meaning that if someone has stumbled onto this scheme, of course, before it has been made public or before the law enforcement is brought in, then that's a different scenario. That's generally what happens is in a business scenario, one of our clients finds that there's something funny or they're not getting paid. And then we start to demand to look at books and we find that there's some pushback it's odd. So if we find things quickly, we can move more quickly. But to answer your question, if the investors come, the first problem that I have as a lawyer is, can I represent all the investors? What we know from the Madoff scheme, the $65 billion scheme, is fairly quickly that transpired into investor versus investor. Because different investors are situated differently based upon what they knew or didn't know. So I will assume that in most cases, we would not end up representing all investors. We would end up representing either those commonly situated or those who came to us first. And the reason that's important, as you said, when there's a limited pool of money, obviously, if there's $150 million fraud, 70 million is gone. 80 million is there, take off the expenses that go through bankruptcy. There's going to be not enough money to make anybody whole. And then, so the question for any investor who comes in to see us is, do we have the opportunity to advantage you versus other people who may have been victims of this scheme? And well, that doesn't necessarily sound fair. It's not necessarily our job to be fair. As counsel, it's our job to represent our clients and obtain the best result as possible for them, as you know.
Yes, yes, indeed.
Yeah.
One of the problems, Bill, with a scheme like this, and of course you've just hit upon it, is that the scheme itself chews up a lot of assets, and just keeping the thing going, making those minimum payments as they come due to this large number of investors, in and of itself depletes the assets of the fraud entity, whatever it happens to be, or entities, as in this case. So what do you do about that? So that money's sort of gone. How, what are the approaches to making any meaningful efforts to recover any of that?
So I think at the very beginning, you have to start and assume that there's only going to be minimal recovery from the assets of the frauding entity, especially in this type of scenario where it's a pure Ponzi scheme. As you know, many times we see a mixed Ponzi scheme. That is, there may have been some business that was being operated, but the business wasn't being operated profitably. So the people involved in the business engage in some type of Ponzi scheme. In those situations, then you can look to some assets. But in a pure Ponzi scheme like this, there are no assets because the only assets are those monies defrauded from the victims. None of them have been invested. None of them are in any type of place where you can go immediately and get the court to freeze them. Obviously, in this situation, we see that the government has done what it can to take those assets. So I think at the very beginning, what you have to do is say, we're not going to get our money. We're not going to make you whole. We're not going to come close to that based upon the assets that are there. So you start in the beginning and you say, who else could be responsible for this loss? One interesting aspect of this particular situation is in order to get a leg up on finding investors, these folks purchased a book of business.
Right.
And it says that they purchased that book of business from an investment advisor and conducted their scheme under that advisor's, if you will, auspices. So I would want to start looking at more into that investment advisor. Is that investment advisor affiliated with a large company? Are there assets there? Because there are due diligence questions. And again, they're questions at this point you don't know until you investigate them as to whether that's a potential source of recovery. Another source is how long did each of these companies stay in business? Were they ever audited by an accounting firm? And if so, I would want to take a look and see the extent to which that audit looked, or if they weren't audited and they were at least reviewed in some manner by any professional, I would want to take a look and see what that review was and see whether there is something there. It's always easy to say in retrospect that the fraud should have been found. And I think in many cases, we find that the fraud really was sophisticated enough that it couldn't be found. But there are situations, as you know, where the professional isn't doing her or his job. And had they done that job, at least there's a good argument to be made that the fraud would have been caught earlier and it would have diminished the loss. So to bring that around first circle, what I like to do at the beginning of a case is from the day one when the investor comes in or the loss victim, start looking at what are all the potential aspects of recovery. Is there insurance in place? Does the investor have insurance in place? So the potential sources of recovery are a mix of not only the traditional scammers, but all those other sources in a regularly run business or in a wealthy individual where there might be sources. And then at the same time that we're looking at justifying taking certain actions, we're looking at what the outcome can be. So it's all well and good to pursue actions, but if there's no money at the end of that rainbow, it's a waste of time. So we're at the very front end saying, all right, if there are other sources here, are those liquid sources? Are they solvent? What's the difficulty in going after those sources? What's the likelihood of recovery? And then is there a way that my investors are differently situated, or can we move more quickly than someone else to go after an asset that might deplete and be able to do that legally and properly?
That makes perfect sense. One of the interesting points that you hit on there a moment ago is that there's this whole sort of cloud of, I'll call them professional facilitators that may be involved here. Who drew up the offering documents, who sold the book of business, what, did they properly inform their clients of what they were transferring them into? There are all sorts of third parties out there that could represent potential gold mines for recovery. Is there any benefit, though, in using the powers of the bankruptcy court in a case like this, even if the bankrupt estate ends up with zero assets? Is that something that's a useful tool to have in the tool chest in something like this?
Yeah, so generally we see the scenario one of two ways. Either it is an entity that is in bankruptcy, or if we're lucky enough to be there before the entity has been pushed into bankruptcy, are there things that can be done prior to bankruptcy that don't create preference or other issues, which we can talk about. So I think to me, I don't look at it as Um, are there benefits or detriments? I look at it as if the entity is in bankruptcy or going into bankruptcy, then we do certain things. The bankruptcy court obviously has um, certain things that can be done immediately. If there's any asset to be run or any asset to be collected, a receiver can be sought. There are different levels of investigators who can be appointed by the bankruptcy court. The bankruptcy court can immediately put in place orders to preserve assets. Now, what we don't know in this situation was whether any of those types of things happened prior to the federal law enforcement involvement, or if the law enforcement involvement was first. If the law enforcement involvement is first, your options are much more limited.
Right.
But the bankruptcy court does have the ability to marshal the assets that are easily brought in. And then there are certain, let's assume that there is an ongoing business of any type. There are certain, you can keep that business going for a while. You can avoid getting the entity evicted because it didn't pay its rent until you could do a forensic examination of all the premises and the computers. So those types of things are helpful. But in the end, what I would say is that all of those benefits in some ways are outweighed by the fact that once the entity is in bankruptcy, it becomes much more difficult for an investor to differentiate themselves from potentially similarly situated victims. And that's the key in these cases, in my view, is good lawyers and get a better result for their clients because they're able to differentiate themselves and do different things than the other investors do, because there are limited pots of money and limited opportunities.
Well, yeah, that's exactly right. And that's a great question for people to ask themselves prior to potentially forcing an entity into an involuntary bankruptcy. Is that balance about, gee, am I, the benefits that I derive from this? And the thing I was thinking about, of course, was that especially in the case of the receiver then stands in the shoes of the entities. And so in terms of dealing with the professionals and getting records from them and things like that, the bankruptcy court has powers that the individual victims wouldn't have. But on the other hand, your point is very well taken, which is, yeah, but if you got all that power, and along with that power comes along an enormous number of other people that are going to share in whatever is recovered as a result, are you better off or you worse off? I think that's a great point.
Yeah. And Bill, as you know, there are other mechanisms that there are other avenues that could achieve the same result. So in matters that we've had, I can think of at least one or two where, in lieu of bringing an entity into bankruptcy court, we've gone either to federal court or to state court to get a receiver appointed before the entity goes into bankruptcy. And we'll do that sometimes if information is gold, because information, if it's reliable, tells you where you can recover assets. So if I can, on behalf of my clients, get you in the door and looking at the books or getting access to the computers prior to it going into bankruptcy, that's my preference in every single case. Because once it goes into bankruptcy, yes, there are ways you can get that information, but you can't get it as quickly as I think it's helpful to have that information if you want to differentiate yourself from other potential loss victims.
That's true. I on our matter, I wore out an entire team of electronic discovery experts. I kept them working around the clock for a week, probably.
Well, and Bill, and that's a good example in that matter, because it had not yet been in bankruptcy. We were able to go talk to potential witnesses as to not only understanding how the fraud had occurred, but also understanding where the monies might have been diverted to.
Yes.
And I think that's key. once it goes into bankruptcy, you obviously have dangers. Anything that your client has received within 90 days of bankruptcy, you have to assume is going to be brought back into the state as a preference. Limited exceptions to that. And then I think you also have to look at whether your client these days, and this is the Madoff situation that taught us this immediately, is my client vulnerable to be sued by other people who are claiming that my client should have known based upon what their position was in this scheme? Were they in early enough? What information did they have? What risk do they have in bankruptcy? So the bankruptcy is a double-edged sword in some respects, because the bankruptcy trustee has the ability to bring claims in order to bring money back into the case. And again, using Madoff, because everybody we know is familiar with that, that trustee did bring claims against people who had actually been defrauded, but determined that there were differences in what they should have known or did know, and tried to bring a lot of that money back into the estate. So it's a double-edged sword depending on how your client's situated.
Right. So in that instance, so you think, gee, thank God I at least got some of my money. And then all of a sudden you discover, well, no, I didn't, because now the bankruptcy court's taking it away from me and using it to compensate other investors. So yeah, that's a huge downside. Hey, I wanted to talk to you a little bit about these third parties. Is it always necessary, and you did a very good job identifying who they might be, is it always necessary to win litigation against them in order to make recoveries? In other words, you have to make decisions about, hey, I'm going to spend so much money on litigation. Am I really going to recover enough from this accounting firm or this, chartered financial analyst or whomever, banker, whomever, to make my investment in the litigation worth it? So you have to go all the way to the end and actually get a judgment and enforce that judgment to make those recoveries?
And I think the answer is definitely not. I think the ideal situation is to have investigated and have enough information so that the claim that you can bring on behalf of your particular client is so compelling that the entity, which might otherwise be a very solvent, legitimate entity, sees its exposure and is willing to settle with your client fairly quickly. In fact, I think there are opportunities there. Let's assume, for example, that a professional has made an error, and you have information from your client that your client did in fact rely upon that professional's assertion. I think there's a great advantage to reaching out, putting together your case, perhaps even preparing the complaint, be ready to file, and especially if it is a legitimate entity that has insurance, sitting down with them saying, this is what we're going to file, and we won't be the first. And let's assume that that entity has a $5 million policy for errors like this. I think it's very possible that they may want to settle with someone who has figured that out and take the risks that other people won't figure that out, and do it for an amount that's under their policy limits. I think there are lots of opportunities like that. So filing litigation can happen, but it doesn't have to happen.
That is an excellent point. I don't want to get too much in the weeds, but I think people need to realize, people always think, well, I'll sue them, and I'll win in court, and I'll get a judgment. And the problem with that strategy is it often can, maybe you're right, maybe those things will happen, but it often ends up being a Pyrrhic victory. And you mentioned those insurance policies. And this is where I don't want to get too far into the weeds, but I really want to illustrate why your approach is so important in cases like this. And I've been involved with you as you've proceeded against these third parties, and your approach has always been get in early, have the facts, be ready to make the compelling argument and to demonstrate that if we have to go to trial, we're going to win, but do that with a view to finding a way to reach an agreement about settlement before any of that stuff happens. And the point I wanted to make is a lot of these, especially the professional liability policies, are wasting policies. And so money spent on lawyers and forensic accountants and others are not available to compensate victims. Those monies are gone. So it's a very, very, very good point that you make.
Yeah, I think, Bill, the key from the start is two words: maximize recovery. That's your job in a situation like this. Now, you and I know we've had cases over the years. You first have to interview the client and understand what their objectives are. Every once in a while, you'll have a client who wants recovery, but certainly at the beginning wants vindication.
Right.
And wants to see the wrongdoers go to jail and do all that. We can do that case, but many times that case is antithetical to maximizing recovery. So you tend to have, and then we have clients that have, they're pure business minded, and they'll let somebody else go after that, and they just want as much money as they can get out of this as quickly as possible without expending more. So you've got those two extremes. And then quite often when you have folks who first come in your office that are all keen on vindication, about 2 years into the litigation, they switch and all of a sudden they say, well, why didn't we maximize recovery? So right. it really does depend. If it is a business situation, I really try to encourage my clients to think about maximizing recovery, minimizing loss, and letting other professionals that get paid by the government or otherwise obtain the retribution that they might want.
Right. I've only ever had one client who stayed the vindication path the whole way through. And I can't say too much about them because they're very, very well known. But the fact of the matter is, of course, that they are also billionaires. And, after that, I came up with a saying that was, you should be very careful before you, malign family members of billionaires. It can get awfully ugly.
Well, Bill, this will date both of us, but I seem to recall a case back in the early 90s that we both worked on where the particular company involved was one of the best funded companies in the world, and their interest was vindication. And we made a lot of law along the way, and it was great for lawyers, it was great for accountants, and I think they obtained what they wanted. Yes. But that certainly is the exception and not the rule.
Absolutely. But they all, every client I've spoken to in a matter like this starts out wanting vindication, and I always had to have that conversation about, well, let's think down the road. Let's say you get everything you want. What does that look like? What does that outcome look like for you? And they explain it, and then I explain to them some of the challenges about, having to choose one avenue over another, so yeah, we could turn it over to law enforcement, but when we do that, we're going to lose control of it, and all the civil litigation is going to get stayed until the criminal litigation's over with. And, it's going to, time value of money, it's going to take a long time to get through that process, if ever. And, that's fine. I mean, it's your decision to make, but you just need to know those things before you make those decisions.
Yeah. And Bill, I think, I know you want to keep this to about 30 minutes. This is a good point to kind of bring to CODA, but what makes me feel good in a recovery in the situation, again, is not necessarily if I can do as well as everybody else who's been a victim, but if I can think creatively working with you and others and achieve a much better result. And the matter that was somewhat related to this, at the end of the day, the bankruptcy, those creditors who were arguably similarly situated went through the bankruptcy process, got back pennies on the dollar. Our client got back more than 80 cents on the dollar. And if you can look at the end of the day and say, we were able to do something completely legal, completely valid, and then we've done our job for our clients. And that's the best we can say in these situations, because you have to start out with the idea that you don't want to be here, you're going to lose something, and how do we make the best out of that situation?
Well, that's a great way to end this. And for those of you watching this podcast, you are hearing from one of the most creative, gifted lawyers I've ever had the privilege and honor to work with over the past 40 years. I've seen him pull rabbits out of hats that, frankly, even caused me to shake my head. So, Bill, I want to thank you very much. There undoubtedly will be people who have questions and will want to follow up. Is there a way that they can get in touch with you?
Absolutely, Bill. We have a wonderful webpage for our firm, Parker, Hudson, Rayner and Dobbs, at www.phrd.com. My email address is wjh@phrd.com, and my direct dial number is 404-420-5544. These cases are complex. They create in order to be successful, you have to have a team that's willing to jump in quickly and work with professionals like you. So we find them amazingly challenging, and I'm always happy to talk to folks. And quite often, not quite often, but sometimes we'll talk to them, and it's not the right thing to move forward with us, and that's okay too. But always willing to talk.
Yes, indeed. Same here. Thanks so much, Bill. I can't tell you how much I appreciate it.
Bill, thank you, and thank you for all the good work we've done together over the years. It's been a lot of fun.
Yes, indeed, it has. It has.